is Marie Haycock, and I'm going to be discussing Chapter 7, Negligence and Malpractice. According to Buppert, malpractice is the failure of a professional to exercise that degree of skill and learning commonly applied by the average, prudent, reputable member of the profession. And negligence is the failure to follow up, refer when necessary, disclose information to a patient when necessary, and failure to give necessary care. Negligence is a legal theory to address who is at fault. A negligent act may be in forms of diagnosis, treatment, or aftercare. Malpractice is when an individual has caused unexpected complications to a patient from the act of being negligent. This is how negligence becomes malpractice. To do no harm is every NP or provider's daily routine list. However, when providers are making multiple decisions throughout the day, sometimes mistakes are made. Malpractice lawsuit incidents are difficult to identify because of these reasons. A person who believes they have been harmed must file the suit in the state that it happened. The blame could be placed on the wrong person, and the definition of malpractice may not meet the claim. Following the claim is limited because of these. In the early stages of the suit, the individual at fault may not be known because sometimes the NP may be a team member in the group being sued. And then insurance companies must report a damage reward to the National Practitioner Data Bank. The individual or the plaintiff must provide evidence for malpractice. If they do not, then there is no report filed to the NPDB. The life cycle of a lawsuit. The first step is to file pleadings with a state court within the county. Depending on the state, the claim could be directed to an arbitration panel. The case is presented to a panel and the members vote. The case is made when either party makes an appeal depending on the state law. Next, the judge or the jury favors a party at a trial. Then either party can appeal for a state court. Federal court appeal is rare for malpractice cases, although it can happen. Once at the state level, many parties will actually drop the case at the state trial. The information at the state trial is not published unless they are appealed. The opinions of the appeal courts are available for the public view for professionals and attorneys to use for malpractice cases. There are 4 components of malpractice that need to be included by the plaintiff in a malpractice suit. Number 1, the NP owed the plaintiff a duty. Number 2, the NP's conduct fell below the standard of care. Number 3, the NP's conduct caused the plaintiff's injury. And lastly, the plaintiff was injured. The duty. There's a provider-provider relationship that is accomplished through an office visit. However, the duty can be established through a phone call or a conversation with an individual who's not yet a patient. NPs can give professional treatment advice in a group setting. Standard of care. The duty bound to provide the standard of care by the exercising skill, care, and diligence in practice. A reasonably and prudent NP is held to the standard of care. In many primary care cases, the NP is held to the same standard of care as a physician practicing primary care. In a malpractice case, the standard of care will be argued in court, and if the NP believes that the standard of care was met, expert witnesses will be called in to explain the actions of what a reasonable and prudent NP would do in this situation. The next component, the breach of the standard of care, caused the injury. For example, an antibiotic is prescribed for an infection. The antibiotic happens to be an allergy of the patient. The patient is stung by a bee, they fall and hit their head on the front steps of the clinic and is left with a scar on the forehead. The patient then tries to sue the clinic for malpractice. The NP had a duty of the patient. The standard of care was breached, which was prescribing the antibiotic that the patient was allergic to. and there was an injury to the patient when they fell and hit their head. However, there is no claim because the breach of standard of care did not cause the injury or the wound to the head. Again, if there is no injury, then there is no malpractice case. All four components must be provided by the plaintiff for a malpractice case to go any further. Some examples of malpractice include failure of diagnosis, a failure to obtain the medical history, to perform a physical exam, and order necessary labs or tests, and therefore no diagnosis was made without that information. Failure to diagnose in a timely manner. The patient suffered because the provider did not obtain the correct diagnosis. Failure to treat. The provider did not follow the protocols or did not order necessary treatments or tests. Medication errors. Ordering medications that interact with one another, causing a medication interaction with a patient. Giving an incorrect medication or the incorrect dosage. Also, another example is shared liability with the physician. The supervisory physician can be sued for the NP's actions. Delegating tasks to the NP does not mean that the physician delegated legal obligations, as the NP must be aware of their state's scope of practice. The National Practitioner Data Bank is a national depository program that records information about medical malpractice payments. It also holds records of practitioners' adverse actions by licensing boards, hospitals, and professional quality assurance committees. This data bank is created under federal law for hospitals, state licensing boards, and other hospital services to discipline those who participate in the unprofessional practices and report the dangerous practices by physicians, dentists, and practitioners who move from different states to prevent this from happening again. Damage awards must be reported to this data bank and the state licensing. Malpractice insurers who pay the plaintiff in an NP case must be reported to this data bank also. However, if an NP or provider directly pays the plaintiff, this does not have to be reported to this data bank. Before allowing clinical privileges, hospitals are actually required to check this data bank every 2 years, and agencies can also check it. NPs can see their data bank and add their commentary to their incident in the database. Guidelines for practice. So in review, in Kansas, the NP must practice under a physician, provide primary, secondary, and tertiary health care. Authorization for collaborative practice. The medical care plan is developed and managed by the NP and signed by both the physician and the NP. NPs can prescribe medications with a written protocol as established by the physician. It is important for the NP to practice by their state law and guidelines. They must follow written guidelines that should follow criteria as outlined by Buppert. These include guidelines that should be written clearly, they're reasonable to follow every day, they're evidence-based practice resources. If the guidelines are not appropriate for the patient, documentation of a different approach needs to be done. If the patient is non-compliant with the guidelines, documentation of the efforts of trying to get them to follow the treatment plan needs to be documented. The Agency for Healthcare Research and Quality has set guidelines for practice with what works or what does not work in prevention and treatment. This agency has guidelines for different conditions, and the NP that can use this federal agency as a resource when providing care for a certain condition. So how to prevent malpractice? Providing that patient-provider relationship, the NP must be careful when and where this is taking place. For example, the NP could be out and about and run into somebody that they know, their neighbors, and they can ask them a question about healthcare or their personal needs, and that NP needs to be very careful on what they are saying and making sure they're following the guidelines, being knowledgeable and practicing their standard of care in their state, following those agency guidelines or protocols, and then ruling out the worst diagnosis first, taking a conservative approach and not using those risky behaviors, training and expertise limits, and then of course following up with any kind of change in treatment, change in patient status. So preventing malpractice and negligence has many pros to it. Monitoring and paying close attention to detail about patients, follow protocols and contraindications, scope of practice, the standard of practice protocols, and care for patients to prevent harm. Screening to find out what conditions or injuries the patient has and what medications the patient is on. And a major one is asking questions and just not assuming. Educating the patient about risks of the treatment plan so they can decide to further. Keeping records up to date and to treat patients properly, and noting changes to medications, side effects, or any sudden changes. So what should an NP do if they are sued? Their professional liability insurance needs to be called to report the lawsuit. Do not talk about the case with anyone except your attorney. Do not talk with the plaintiff or their family member or the plaintiff's attorney. If the suit is against a group, the NP might consider hiring their own attorney to represent themselves. Do not change anything in the record, especially after the case is open. The deposition or the gathering of information stage is very important because what the NP says and reports kind of locks them in for what needs to be said at the trial. Before settling with the plaintiff, it's important to think about it because the settlement awards are reported back to the NP's National Practitioner Data Bank record. Communication. It was found that providers with malpractice suits against them spent 15 minutes with each patient, and providers with no malpractice suits spent 18.3 minutes with patients. So just that little bit more time prevented those malpractice suits. Quality of care is a key, as provider-patient communication equals better outcomes and fewer lawsuits. Those patients with satisfied care will definitely not be pursuing any lawsuits. Malpractice insurance. NPs can purchase individual malpractice insurance even if their employer has insurance for them. There is two different kinds. There's claims or occurrence insurance. Occurrence covers any event that happened while the NP was insured. Claims covers only when the NP's policy was active. It does not matter when the event occurred. So for example, when the NP retires, the claims policy should be kept active in the event of past incidents that might come up and result in a malpractice suit. It is best to choose a company in the U.S. that has been established for at least 10 years and a stable financial rating. I found this chart on the Kansas rate of malpractice insurance by specialty. As you can see, the highest rate is those with surgery. So these are for providers, and so for nurse practitioners for family practice is about $5,084 per year. It is required by law that providers in the state of Kansas purchase professional liability insurance. The policy must have claims of $200,000 and an aggregate limit of $600,000. Providers must purchase insurance from a state-admitted carrier, and those are locked and guaranteed by the Department of Insurance. Healthcare Stabilization Fund is an additional coverage plan to the liability insurance that is required for all providers to carry. And there are options to choose from and is added to the surplus premium with the liability insurance. Just a few companies in Kansas are the Medicus, Kansas Medical, ProAssurance, Professional Solutions, the Doctor's Company, and Midwest Medical Insurance. And then, like I said, cost is dependent on the amount of coverage purchased. Some cons to a malpractice negligence case include if the damage awards are given to the plaintiff, the NP will be reported to that National Practitioner Data Bank by the NP's professional liability insurance. The state medical board can investigate the case if the NP has a number of settlement or losses within a designated time frame. Professional liability insurance rates may go up if the NP is sued, and it is important for the NP to keep records from the lawsuit in the event that the case would reopen. So kind of in review, the impact on the NP's practice. The NPs obviously have state laws and regulations that a reasonable and prudent NP would practice upon. Negligent behaviors can lead to malpractice suits. Communication with the patient and supervisory provider is imperative. Attention to detail of the patient's care, documentation of interventions taken. Guidelines must be followed within the agency or place of work. And then professional liability insurance is required by all advanced practice providers. It is a peace of mind and well worth the money. I hope that you enjoyed my presentation. I learned a lot through researching malpractice and negligence, and it is important to keep these topics in mind as we have many tasks to accomplish every day, and it is easy and simple to make a mistake. We are educated and provided with the necessary skills to perform as a professional, prudent, and competent nurse practitioner.